अच्छा आप तो लोग પુરવણી છે પેલું પૂરું થવા હા 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 એ જ. હા હા બરાબર હા મને પેલું આપણે પૂરું થઈ ગયેલું છે આ ચામુંડા માતા મંદિર વાળું પેલું આપણે એને પરમાર જેવા તો તપાસ ખાલી જાતે જ આપી દો. થર્ડ થર્ડ જાબર જાબર તમે બેસો એક જ સર્વે નંબર છે, અલગ અલગ બંને સરખું છે. માંગી લે આજે લખે નોકરું ચાલે ટાઉન છે બધા જાય કે કોઈ તમારે જોતા આવે હા આવી ગયું આવી ગયું ચાર્જ નો બંધ થાય છે આમાં જે સાથે નહોતું પણ એપિસોડમાં આ છે હા જે દીદી સ્વપ્ન ચક્કર પછી એના તારીખ મોટા સ્ટેશન લાયા આપણે નંબર હા બેન આવી ગયા ચેકની અરજી હા.
હાજી હાજી એમાં ભજવા પર ચાલે છે.
મીટરમાં કરાવી દઈએ.
Request the Honorable Court. Yes, MS Shavanan. Yes. I'll request the Honorable Court to just look at the FIR first on page 1. For duration, mainly for the duration for which it has been filed. It is dated 28th of October 2024. The period which is mentioned is from 27th of May 2016 to 12th of May 2020. Most importantly, the sections which are referred are from IPC. When the complaint is filed in the month of October 2024, Bharatiya Nagrik Suraksha Sanhita was implemented on 1st July 2023. मतलब 28th of October 2024. I'll take your lordship first to the facts of the case, and then we'll address on the merits and the law point. Well, just have the FIR, 4th page. I am arraigned as accused number 32, Leelaben Naranbhai Patel. Yes. Naranbhai is the father of the Leelaben. Uh, 32, 32. Leelaben Naran. Am I with you? On page number, internal page 3 of the FIR. Internal page 5, column number 12. What is the crux of the FIR? I just read the one paragraph. Then Indian Penal, am I with us? Indian Penal Code કલમ 406, 420, 465, 67, 16 મુજબના કામે ફરિયાદી શ્રી નાઓએ ફરિયાદમાં જણાવેલ કોષ્ટક નંબર 112 માં જણાવેલ કુલ 75 આરોપીઓએ તેમના અન્ય મળતિયાઓ સાથે ભેગા મળી પૂર્વ આયોજન કરી 27/5/2016 થી 12/5/2020 ના સમયગાળા દરમિયાન કોઈપણ વખતે મોજે તાલુકા પંચાયત કચેરી દાહોદ ખાતે ફરિયાદના કોષ્ટકમાં જણાવેલ રેવન્યુ સર્વે નંબરના બિનખેતીના હુકમો હેતુ ફેરના તાલુકા પંચાયત કચેરી દાહોદના નામના સહી સિક્કાવાળા ખોટા બનાવટી બિન ખેતી પરવાનગીના હુકમો બનાવી તે હુકમોનો સાચા તરીકે ઉપયોગ કરી સરકારશ્રીને રૂપાંતર પ્રીમિયમની રકમ ન ભરી સરકારશ્રી તરફ ઠગાઈ વિશ્વાસઘાતક સરકારશ્રીને આર્થિક નુકસાન કરી ગુનો કર્યા બાબતનો This is the sum and substance. But મતલબ I'll take your lordship to the entire FIR. No categorically role is defined. It talks about 112 orders. And I am an owner of only one parcel of land. Now, on the next page, who is the complainant is mentioned, how the complaint came to be filed in second paragraph, and then what are the lands involved is mentioned on the entire 4-5 pages. Then on page, I am at 49, serial number 49. My land is mentioned at serial number 49. On page number, internal page number 9. Village Delsar, 35, 1D. Yes, 1D, P4, Paiki 1. Honorable Court, kindly have internal page 13, concluding paragraph. Second last paragraph, more particularly. Internal page 13 of the FIR. Running page is also 13. The second last paragraph. વધુમાં જણાવવાનું કે am I with my loss? Yes. After ઉક્ત જણાવેલ 112 હુકમો પૈકી મામલતદાર. So that is again a repetition how the premium has been siphoned away, and that is allegation. Now what most importantly વધુમાં જણાવવાનું કે ઉપર પૈકી હા 11ના 112 ખોટા હુકમો સિવાયના अन्य 885 સંદિગ્ધ હુકમો બાબતે પણ તપાસ ચાલી રહેલ છે. Lordship may just mark the number of the સંદિગ્ધ હુકમ 885. So my intention is just to કેટલું 85. Okay, so then 85. My endeavor is just to show that I am a owner of only one land. Allegation is to the effect that in connivance with someone or some others, the offense has been committed by 75 accused. No specific role is assigned. That apart, how the Honorable Court may kindly have page number 15, item number 2, which has been produced. But this is a revenue entry whereby land has been purchased. Two entries we have produced. Page 15 and 16 refers to page 15 and 16. Two. Entry number 2755 and 2793. It is marked as document 2 by 15. Just after the FIR. Yes, yes. 2755 revenue entry. And on the next page, revenue entry 2793. I'll just read 2793 on the next page, so it will make clear. Yes, sir. Registered દસ્તાવેજ અત્યારે હક કમી નો. The land was standing in my name. The rest of the owners have removed their name by executing the document. દેલસર ગામના ખેડૂત ખાતેદાર લીલાબેન નારાયણભાઈ ભગવીન દીકરી સંયુક્ત નામે ખાતી ખેતી ખાતા નંબર 100 વાળી ખેતીની જમીન આવેલી છે. તેમાંથી નીચેના હિસ્સેદારોએ પોતાની અરજીથી ખાતાની મિલકતનો સ્વકૃત પોતાનો હક કમી કરવા અરજી કબૂલાતનો દસ્તાવેજ કમી આવેલ છે. That is how the entire land stood in my name on 1/7/2015. Thereafter, I sold away out of that few portion of land, which is on the next page, page number 18. Revenue entry number 2858 by executing registered sale. On entry number 2858 on next page, page 18. As such, not required, but just to assist the honorable court to understand the how we purchase the land and how we are law abiding citizen. That is what my endeavor is to. But now, after having remaining land, on page 20, the honorable court will find the order of converting land into old tenure land. Yes, I'm sorry, that is not much legible. Page 20 is that order, that black. Item 5/20, serial number 5/20. सब આવું દેખાય છે થોડું કાળું છે સર આઈ સોરી હા 13/12/17 નો છે સર એ ચલણ એની પહેલાનું સર એની પહેલા છે
એની આગળ પેજ
applicant is a lady. She applied to get it NA permission converted to one Ghanibai Mansuri, who works as a broker in Dahod, land broker. Even we have purchased the land through him. Some portion of land was also sold via him that we just shown. Ghanibai Mansuri. This is also through Ghanibai. NA permission was also through Ghanibai Mansuri. And this conversion of land into old tenure land. So let's just see the amount which has been ordered in this order, internal page number 21, bottom portion, 8,25,000 is required to be paid. Bottom portion on next page, second page. Bottom portion, premium ની રકમ 8,25,000, 8,25,000 પૂરા આપણે 100 ના અરજદાર જમીન મહેસૂલ દફતર 21 દિવસમાં જણાવતા. Yes, I'm obliged. So that is how 20,00,000 પૂરા જેને 40% લેખે પ્રીમિયમ ની રકમ 8,25,000. Yes, that we paid. That challan is on page 23. It was paid on 7th December 2017. Till this point of time, there is no dispute. Thereafter, the revenue entry was also mutated, converting the land into old tenure land. That the Honorable Court will find on page 25. On 11, yes, that document. It is 2956 revenue entry, which refers to in second, second paragraph. This is 19/12/2017. મોજે દેલસર તાલુકા દાહોદના રેવન્યુ સર્વે નંબર સો એન્ડ સો બિન ખેતીને હેતુને પ્રીમિયમને પાત્ર જમીન પટેલ લીલાબેન તે નારાયણભાઈ ભગવાનની દીકરી નામે ચાલતી જમીન 4125 ચોરસ મીટર બિન ખેતીના રહેણાંકના હેતુ માટે બિન ખેતીના કામે વંચાણે લીધેલા અમુક નંબર 100 ની જોગવાઈ નીચે છતાં શરત ફેર કરવા જૂની શરતમાં ફેરવાથી હુકમ કરવામાં આવે છે. That order's entry has been reflected in the revenue record 2956. Up till this time, there was never any occasion to doubt that Ghanibai. Thereafter, the disputed document comes from. This challan amount we have paid in the government treasure through online mode and via our bank account. So there is no dispute that we have not paid this 8,25,000 or that order of converting land is bogus order. That is no such allegation. Even it has been admitted in the IO's affidavit that we have paid this 8,25,000. Should I generally in a town place, the brokers are dealing with this land sale, resale, NA permissions. So that is how we came in the contact with Ghanibai. Now, this document now which has been disputed is on page 27, item 8. This is 13th December 2017. This is little unlegible. On the top of it, Lordship will find on the top of it, Taluka Panchayat Kacheri 30/17. The Honorable Court has examined the earlier entry, which is 19th December 2017. On the previous page, it was 19th December 2017. Earlier page. It was 19th December 2017. So converting land into old tenure land, it is 19th December 2017. Thereafter, this 13th December 2017 order was handed over by Said Ghanibai. And in that, the Honorable Court may have second page what amount we are asked to deposit. On the top of it, on page 28, second page, સબબ ઉપરોક્ત વંચાણે લીધેલા અમુક નવ. Am I with my lords? Yes. અમુક નવથી સદર અરજદાર પટેલ લીલાબેન તે નારાયણભાઈ ભગજીભાઈની દીકરી નામે મોજે 100 સર્વે નંબર 100 વિસ્તાર 4125 આકાર 3 વાળી જમીન પૈકી 4,000. Lordship may just mark this 4,000, which I'll later on come to it. પૈકી 4,000 ચોરસ મીટર જમીન રહેણાંક હેતુ માટે બિન ખેતીનો રૂપાંતર કર 8,000 પૂરો ભરવાનો થાય છે. આ કર 35 કૃષિ 100 માં જમા કરાવી અત્રેની કચેરી નકલ સાદર રાખા. This amount is only rupees 8,000. And then on page 29, para 20, the calculation has been given wherein only rupees 1,850 is required to be deposited. May I read this paragraph? ખેતી સિવાયની પરવાનગી અંગે કામે પોરી નીચેની વિગતે બિન ખેતી ઉપકરણ રહે છે. આ કામે વખતો સરકાર દ્વારા પ્રમાણે અરજદાર ભરવાનો છે. બિન ખેતીનો આટલા, લોકલ ફંડ આટલો, શિક્ષણ વિશેષ વીપી શેષ અને તાલુકા પંચાયત શેષ 1850. In substance 9,000 850 around. In a very small amount, Ganibhai assured that he has paid it. So we never have any occasion to doubt the Ganibhai, because Lordship will now see the next page. Even revenue entry for this order was also mutated in the revenue record. Thereafter, next page, thereafter. Yes. Is page 32. Yes, page 32. Grateful, Malas. This is the revenue entry of that order. It is dated. Some closer scrutiny of this document is very much necessary, crucial. This is dated 19th of February 2018. Lordship will find just below the revenue entry number 2962, 19th of February 2018. It refers to what it says. દાહોદ તાલુકાના મોજે દેરસલ ગામના ખાતા નંબર 450 સીમ જમીનના સર્વે નંબર 4140,125 જૂની સર્વે ચાલે જે જમીન રહેણાંક નેટમાં પરવાનગી અંગે દાહોદના હુકમ નંબર 180 ખાતેદાર પટેલ લીલાબેન નાણાભાઈની દીકરી નામે 100 હેક્ટરની જૂની સર્વેની ચાલે જે જમીન પૈકી 4000 જમીન 4000 જમીન સ્ક્વેર મીટર રહેણાંક હેતુ માટે બિન ખેતી હેતુ ફેર કરી આપેલ છે ને જે નીચે મુજબની શરતોને આધીન મંજૂર કરવા આથી હુકમ થઈ આવતા હુકમની નોંધ કરી. This entry in the last column has been certified on 23rd of March 2018. પ્રમાણિત. Am I with me? On the last column. Circle officer has verified this order. It is written that મહેરબાન તાલુકા વિકાસ અધિકારી સાહેબ દાહોદના હુકમ નંબર 100 30/17 થી ખાતરી કરી પ્રમાણિત સહી KC Charpot, Circle Officer Dahod, 23/3/18. Therefore, there was never any occasion for the applicant to even think about that this entry or this order has been managed order or forged order. Honorable Court may just note that fraudulent order, alleged fraudulent order is of 13th December 2017, which we referred on page 27. And this entry is mutated on 19th of February 2018 and certified on 23rd of March 2018. So within 3 months, the entire transaction has been completed by mutation entry. So what my endeavor is to, if at the time of mutation, it was found that this entry has been wrong, this order is false order, immediately even we could have given a complaint that we have been a part of fraudulent transaction. We are on the contrary victim. But since revenue entry was certified, Honorable Court may consider the height. Now we plot this, we after NA permission, we made plotting in this land. Thirty-six plots were made. of the land. And as on today, in 2019-20, all plots were sold. Within 2.5 years, thereafter the purchasers have got the permission to build houses on them, the said land. And as on today, houses are standing on the land. In between, on plots. In between period of 7 to 8 years, there was not a single occasion for them to inquire about. That persons who have built up the houses would have asked for Raja Chitti, would have tendered that NA order. Every time this procedure would have been done. But not a single time it was found that this is a fraudulent order. All 36 plots are now, Lordship may just see page 37 to 55 index copies I have produced, which I have sold in 2020 and 2019. It starts from 37 to till page 55. And page 56 is layout plan of 36 plots. And top of it, one revenue proceedings was conducted in 2024. I'll just take a lordship later on that. Let me just note down that few photographs are also there. My lords must have noted photos on page 57. The houses are shown in that land. Page 57. And now, Lordship may just note the glaring fact. On page 59, there is one revenue proceedings order. I'll just read only one paragraph on page 74. This is revenue proceedings by Shagan Bhai, Badriya Bhai Nisarta, past owner, against the Leelaben and all subsequent purchasers. The crux your lordship will find only in one paragraph on page 74. So without taking much time of the Honorable Court, on page 74, last paragraph. Well, internal, it would be page 74. It's a bulky order. It has no relevance as such, but the observation which the yes, just above the hukam, I read only one paragraph. So it will cover what is the crux of the matter. આ કામે મામલતદાર શ્રી દાહોદ દ્વારા કરવામાં આવેલ હુકમ સત્તા બહારનો છે તથા વ્યક્તિનો ધર્મ બદલાતા જમીનનો સત્તા પ્રકાર બદલાતો નથી, જેથી મામલતદાર શ્રી દાહોદ દ્વારા કરવામાં આવેલ હુકમ ગેરકાયદેસર ગણી શકાય. પરંતુ મહેરબાન this is important, પરંતુ મહેરબાન કલેક્ટર સાહેબ શ્રી દાહોદ દ્વારા સવાલવાળી જમીનનું બિનખેતી થયેલ હોય મામલતદાર શ્રી દાહોદના હુકમ નંબર 100 તારીખ 16/5/11 ની સામે નિર્ણય કરવો ઉચિત જણાતો નથી. સો ઉપરોક્ત મહેરબાન કલેક્ટર દાહોદના હુકમની સવાલવાળી જમીન બિનખેતી થયેલ હોય સવાલવાળી જમીનમાં હાલ કોઈપણ પ્રકારનો નિર્ણય કરતો અત્રેની કચેરીની સત્તાને પ્રતિબંધિત છે, જેથી જમીન મહેસૂલ કાયદાની કલમ. The court has found that the land has been converted into NA and therefore no action has been taken. Well, this order is passed by Deputy Collector. This order is by Deputy Collector approving his subordinate's order. At till that point of time, 2024, this order is 22nd of July 2024. No one has noticed that this order is fraudulent order. Now, Malas, I have produced one transcript from page 75. This is very much important because I am saying that one Ghani has done this. What had happened? One FIR was filed on 24th, alleging against some brokers, and therefore, husband of the applicant wife called this Ghani and inquired. I'll just give some brief background, then I'll take to your lordships to the conversation between them. So he called him, saying that Ghani આ બધા ઓર્ડરો ખોટા છે એવી ફરિયાદ થાય છે અને ડેપ્યુટી કલેક્ટરે એક લિસ્ટ બહાર પાડ્યું છે જેમાં અમારી સંદિગ્ધ જમીન બતાવી છે તો what is the reality in this? So in that background they had some discussion which has been recorded in CCTV camera. The CCTV camera is showing 2 days back. This is actually 25th of October communication, but I have mentioned 23rd of October so that it tally with the CCTV camera because it runs 2 days late. It is a fault in the system, but that apart, what is the communication is relevant, which will clearly shows that Ghani has said that આ ખોટું નથી અને Ghani કરાવ્યું, which will, my endeavor is to see that this transaction has been done through Ghani I'll read only 2-3 lines and then Ghani मैं નથી કર્યું અદનાને from top of it. मैं નથી કર્યું અદનાને કર્યું છે. અદનાન તો અહીંયા ટેબલ સંભાળતો હતો મામલતદાર નાયબ મામલતદાર ને પ્રાંત સુખાભાઈ. He's a husband of Leelaben. He says અદનાન બી સાચો છે કે ખોટો પૂછી જોજો. ગનીભાઈ ના ના ખરો છે ઘણા ઓર્ડર કરાવ્યા છે. સુખાભાઈ સાચો છે કે ખોટો પૂછી જોજો. ગનીભાઈ તમે જઈ આવજો પૂછવા. બીરેન Biren is a son of Sukhabai. So Biren is a son of Leelaben applicant. ગનીભાઈ કહે છે કે સાચો ઓર્ડર છે પછી શું કામ વારે ઘડીએ પૂછો છો. ગનીભાઈ હવે અમે આમાં આપણો ઓર્ડર જે લખેલો છે એમાં અંદર કલેક્ટરે લખેલું છે કે તમારા પૈસા ટ્રેજરમાં જમા થઈ ગયા છે. તમારા પૈસા તમે ચેકથી આપેલા છે ક્યાં રોકડા આપેલા છે એ પૈસા તો એકાઉન્ટ પેમાં જાય ને એટલી બુદ્ધિ હું બી રાખું છું. ભણેલો નથી તો પણ સુખાભાઈ એટલે પ્રિતેશ એવું કે આ ઓર્ડર ગનીભાઈ જો તમે ઘોડ મટોળ ના કરો એ પ્રિતેશ બધું જ છે ને પહેલા દિવસથી આવેલાનો ગભરાયેલો કે તો કે ખરાઈ કરવાનો છે તો હું ખરાઈ કરાવી દઉં તો જા તું ખરાઈ કરાઈ લાવ હું તને કાગળે લાવી દઉં છું. કલેક્ટરમાં જે આખો કલેક્ટરમાં પૈસા ભરાયેલા છે આપણા ચલણથી વાત થઈ ગઈ છે અહીંયા આવ્યો પટેલ પાસે પટેલે એને કહી દીધું તું જા. સુખાભાઈ એટલે એણે કીધું કે તાલુકા વાળો ખરાઈના કાગળો આપણી પાસે નથી. ગનીભાઈ તાલુકાની ખરાઈ ક્યાંથી આપશે હમણાં પેલો આપતો જ નથી કોઈને તો. બીરેનભાઈ રજીસ્ટર કઈ ભીનું થઈ ગયું છે. ગનીભાઈ ભીનું થઈ ગયું છે સુકાય અને પેલો શોધે અને જમાવે તો આપશે ને. બીરેનભાઈ પેલું ભીનું થઈ ગયેલું એટલે હમણાં કશું મળે નહીં એમ કહે છે. ગનીભાઈ હવે મેં એને કીધું છે કે લખીને આપી દો કે અમારો રેકોર્ડ પલટી ગયો છે તમે લખીને આપો પૂરું કરો. બીરેનભાઈ તો શું કહે છે ગનીભાઈ હમણાં નહીં આપો. So that is how this is the endeavor to show that applicant is completely innocent. She came to know when this transaction came into light by way of FIR. Now I'll just few more minutes. I'll just give the background of the applicant. His son and daughter both are doctors. Her husband is retired government employee engineer. When they are opening the new multi-speciality hospital in Dahod. So my endeavor is to show that they are well-to-do family, well-educated family. There is never any occasion to think for this kind of activity for them. Amount which has been said to be in the NA order that premium ni chori kari છે, that amount is rupees only 9,850 rupees. We have paid 8,25,000 huge amount by way of online transaction to the government for converting the land into old tenure land. So there is no need for the applicant to manage some order for a small amount of 9,500, and there is not a iota of thought in this regard. She belongs to a well-educated family. I have placed on record certificates of all the applicants, the applicant as well as son, daughter. Even their son and daughter-in-law are also doctors. So they are an educated family, never indulge into any such activity. Can be. Educated persons are more dangerous. I would say. But in this background, when they pay 8,25,000 to the government, why would they siphon away only 9,500? That is what my logical. Yes, true, very true. But it's a case that they are also victim, not even knowing that this is something. Yes, very clever, and they can do better than the uneducated. True, Manas. True. I have placed. I'll not take now on the documents much time. I have placed on document certificate of son, certificate of daughter, being dentist, wife, then daughter, son-in-law, and the daughter-in-law. All are doctors in the family. The husband is also engineer, so they would never indulge into such activity of creating fraudulent document. Then, Manas. Yes. Grateful. So, summing up the argument now, the applicant is a lady, aged 60 years, has a permanent resident, well settled in Dahod itself, not likely to flee away from justice. They are also part of, they are also victim in a sense of this fraudulent transaction. That apart, there is no motive as such to commit such crime. They have paid 8,25,000. So, amount when they are paying, that there cannot be any motive or any adverse inference cannot be drawn that this amount they are not able to pay and therefore they committed this crime. It is not a case. Then your lordship may just note that they are willing to abide by all the conditions whichever imposed by the honorable court. Even I have instruction, they are willing to deposit amount of NA order also. The main allegation, the crux of the order, the crux of the FIR is to the effect that by committing such crime, they have committed misappropriation of the government's premium. That is the crux of the FIR. They are willing to deposit by their own the amount of NA whichever required by the order. So it is not that their bona fides are lacking. They are willing to deposit even today that amount, whatever suggested by the honorable court. They are willing to even cooperate in the investigation. The entire case is based on documentary evidences. Even the IO's affidavit says so. If the honorable court has IO's affidavit, only two things I will point out from them, from that affidavit. Straightway para 26 in this. આરોપી ગુનાહિત ઇતિહાસ ધરાવે છે. This is but nothing has been stated. Okay, grateful. Great. Okay. So there are no antecedents. Even I would say then there are no antecedents of the applicant. Plus, para 7 in tabular form, muddao, which has been referred in tabular form, para 7, the column number 7, yes. આ કામની તપાસ, am I with my lords? આ કામની તપાસ ચાલુ હોય અને સદરુ તપાસ રેવન્યુ દસ્તાવેજી પુરાવા ઉપર આધારિત હોય, જે આધારે સાયદોના જવાબ લેવાનો. So what I am insisting upon is that the entire case is based on documentary evidences. And the Honorable Court may have paragraph 11 of that. They have referred various orders. I have gone through them. Saishav is a mediator, the person against whom it is alleged that he has committed this crime. Just like Ganibhai Mansoori, he is the agent. Almost all are of Sasev, only one Jakaria and Harun Bhai. Yesterday, just for the, it's a not binding, but just to put to the knowledge of the Honorable Court that one bail application has been granted of one Najmuddin Abde Ali, who is also owner of the land. Document list. So this with the list of documents, just to show the Honorable Court this is another yesterday's order. Well, just 2-3 paragraphs only from this because it has some relevance only. It's of course it is after arrest. It is a regular bail, but it has some relevance. What is the and I may not read, just your lordships may note down, just I'm relying the para 15 bottom portion only. Para 15 bottom portion. In para 16 criteria, which is well settled. As such, I'll just have a cursory look if your lordships want for para 14. Arising out of the similar transaction of Dahod itself, he is also owner of the land. Para 14, it is settled principle of by deciding bail applicant cardinal principle kept in mind. So I may not read that. Para 15, just 5 lines, last 5 lines. The second, here also they have paid 1 crore 8 lakh rupees as a that through challan of converting land, and thereafter the fact of payment of premium is not challenged by investigating officer. Am I with my lords? 4th line from top on page 6. The second aspect that required consideration is that as per the case of prosecution, the accused has, with the help of the accused, spent money to get forged NA order. Now, in view of the same, creeping through the FIR as well as affidavit filed by IO, both are silent on this aspect with regard to the role of the accused in the crime. Further allegation with regard to use of money is matter of trial since the applicant accused has paid penalty premium amount in the year 2023, much prior to the present FIR. And now the circumstances the court has considered in para 16. In view of argument, what has been considered the period of occurrence of offence, applicant accused is of 70 years of age, The applicant accused has already paid premium amount in government. In the year 2013, we have paid in 2017, that 8,25,000. And considering government's IO by the affidavit, the allege played by the present applicant accused is certainly a matter of trial. And then para 17, here it is pertinent note that as per FIR itself, the timeline of the alleged offence remained in between 2009 to 2018, and the facts of the present case revealed during the examination of various entries in property card, NA order, and other government record. It is worth to note here that the FIR is bundle of about 14 doubtful orders, and therefore here in this case 85 doubtful orders, and therefore completion of each individual entry and filing of charge sheet as well as trial would not be completed in short time. That are the parameters court considered and granted him. Of course, after the this is probably before regular bail. It seems that it is before charge sheet. It is my learned friend has appeared. So it is before charge sheet. It is before charge sheet. Great. Notes may consider one more aspect from the IO's affidavit, only one remaining aspect. They have considered that this order is without jurisdiction, column 5. Some argument was made in column 5, internal page 7 of IO's affidavit. In the bottom paging nation, bottom page 7, internal page 7, para 5. महसूल विभाग सचिवालय गांधीनगर ठहराव क्रमांक 100 तालुका पंचायत am I internal page 7 column 5 IO's affidavit.
Last pass. Part number.
column number 5. મહેસૂલ વિભાગ સચિવાલય ગાંધીનગર ઠરાવ ક્રમાંક 100 ના ઠરાવ મુજબ તાલુકા પંચાયતના 1 એકર 40-48 હેક્ટર ચોરસ મીટર સુધી જમીન બિન ખેતી કારણ સત્તા અપાવેલા સંજોગ હુકમ તદુપરાંત સત્તા બહારનો પણ છે જે વાત અરજદાર આરોપીને ખબર ના હોય તો માનવાને કારણ નથી. The Honorable Court may just consider the order which I said on page 27. This refers to only 4,000 square meter. In the beginning itself, on page 27, in the beginning itself, it is little black, darker black. I'll read only one. ઉપરોક્ત વંચાણે લીધે અમુક એકની અત્રના તાલુકાના મોજે દેરસર તાલુકા દાહોદના સર્વે નંબર 100 પૈકી વાળી 4,025 ચોરસ મીટર પૈકી 4,000 ચોરસ મીટર જમીન રહેણાંક હેતુ માટે અત્રેની કચેરીને 15/17 ની અરજી કરેલ છે. So that is how it is for only 4,000 square meter. So that point will not be applicable, that it is without jurisdiction. As such, if it is false and fraudulent, then nothing to be looked into about the jurisdiction. But just to technically deal with that argument, that the NA permission is sought for only 4,000 square meter. Now, yes, the Honorable Court may just have the orders which are compilation which I have given. This spiral which we have given yesterday, day before. Sitaram Matre is a well celebrated judgment, so I did not refer to it. Or if the Honorable Court wants, may I just go through the Sidram Matre is a well celebrated judgment wherein firing took place and wherein also anticipatory bail was granted. So that is that judgment. First judgment is, I would like to read judgment number 2, that is from Karnataka High Court, which has some bearing in this case. Page 44. Let's start from here. Start from page 44. Recent judgment. Of course, it is for quashing, but the point which it canvasses has some bearing in this case also. It is 13th September 2024. I read from only one paragraph on page 45. What is the dispute? The criminal petition is filed under 482 CRPs under 528 of the BNSS, praying to quash the FIR and complaint criminal proceeding crime number so and so, so and so. Now, this is quashing proceedings. That is why I read that paragraph. Now, my lords may just have page 47 or page 48. Page 48, top portion. What has been argued has been considered by the court. The learned counsel for the petitioner urged mainly two grounds for quashing of FIR, which is as under. The learned counsel for the petition. Am I with my lords? Yes, page 48, top portion. It starts with para 5 and 5.1. The counsel for the petitioner has contended the offense alleged in the complaint was occurred on 24th of June 2021 and subsequent dates on prior to 3/6/2022. But the complaint was filed on 1st of July 2024, wherein the Criminal Procedure Code has been repealed by the central government and new law, that is BNSS, has been come into force on from 1st/7/2024 onward. Therefore, the police cannot register the FIR under the section 150 per CRPC on or after 1/7/2024. Therefore, conducting the investigation and the FIR registered under the repealed CRPC is not sustainable. How this point was raised, how now court has dealt with this argument, the Honorable Court will find in paragraph, the page 68, the order, in the observations at order item 4. Court has considered the entire provisions and then what has been ordered. It is necessary to issue directions. Am I with my lords? In item 4, it is necessary to issue directions that if any offense committed prior to 1/7/2024 and if the FIR registered on or after 1/7/2024, the FIR should be registered under section 173 of BNSS. The offenses shall be registered under the Indian Penal Code apart from any other special law, but the investigation shall be done and final report shall be submitted under BNSS. And then court directed them to register, re-register. But that is how the court has considered that after 1/7/2024, you cannot register FIR under repealed provisions of the Act. The third judgment is from Chhattisgarh High Court. This is also recent judgment. It has direct bearing on this case. That what is to be considered under the amended provision of 482 of Bharatiya Nagrik Suraksha Sanhita. Well, page 71. It starts with page 71. Yes. Great. Well, the first paragraph. The application under 482 of the Bharatiya Nagrik Suraksha Sanhita, when it henceforth BNSS, has been filed by the application apprehending their arrest in connection with crime number so and so, registered at police station so and so, district resident so and so, punishable under section 451, so and so Indian Penal Code. Now, leaving the rest of the paragraph, the crucial discussion starts from para 6. Para 6 of that. Just to save the Honorable Court's time, the relevant discussions are. The present bail application has been preferred under section 482 of the Bharatiya Nagrik Suraksha Sanhita 2023. It is relevant to note that the difference between the erstwhile pari materia provision, Lordship may just mark this, these lines are very important. Difference between the erstwhile pari materia provision of section of 438 of the Criminal Procedure Code 1973. In the erstwhile provision, there were several guiding factors which needs to be considered while granting the anticipatory bail. The new provision, however, deletes the guiding factors which the courts hearing anticipatory bail applications may have taken into account, such as nature and gravity of accusation, criminal antecedent, and the possibility of the accused to flee from justice. This deletion widens the discretionary powers of the court hearing such applications. Para 7. The PNSS, however, incorporated the condition which can be imposed while granting anticipatory bail in light of the facts of the particular case, including a condition that a person shall make himself available for interrogation by a police officer as and when required, a condition that the person shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer. A condition that the person shall not leave India without the previous permission of the court. Such other condition as may be imposed under subsection 3 of section 480 as if the bail were granted under that section. Therefore, the said amendment suggests that provision has been amended in order to widen the scope of anticipatory bail, that when there are reasonable grounds for holding that a person accused of an offense is not likely to abscond or otherwise misuse his liberty while on bail, there seems to no justification to require him first to submit to custody, remain in prison for few days, and then apply for bail. In this regard, it is quite important to note the Law Commission of India in its 41st report dated 24th of 1969 pointed out the necessity of introducing a provision in the Code of Criminal Procedure enabling the High Court and the Court of Session to grant anticipatory bail. It observed in para 39.9 as under. This 39.9, this is of previous provision. Just read for the assistance, otherwise I may read the, yes, grateful, para 9. Further, the Law Commission of India in its 177th report under heading Introduction to the Doctrine of Arrest has described as follows. This is relevant, so I'll read just few lines from this. Liberty is the most precious of all human rights. It has been the founding faith of the human race for more than 200 years. Both the American Declaration of Independence 1776 and the French Declaration of the Rights of Man and Citizen 1789 spoke of liberty being one of the natural and inalienable rights of man. The Universal Declaration of Human Rights adopted by the General Assembly of the United Nations so and so contains several articles designed to protect and promote the liberty of individual. So does the International Covenant so and so. Now, this is about the freedom. And then court has considered in para 10 to bring the lens back on effective review and consideration, the liberty with reasonable bounds for larger good needs to be prevailed, considering the relation inter se between the complainant and the applicant hearing. The idea to reform must be sailed in motion. The idea to keep the sword over the applicant of arrest may not be required as the nature of allegation itself is great large. And accordingly, anticipated bail application is allowed. And the head note is made by the live law that the scope of anticipated bail as compared to erstwhile provision under 438 on page 78 is larger. So it has some discussion about the scope variation what had taken place in the jurisdiction of the court. I had occasion to appear for the work of board. That next order I have produced. A similar, the crime has taken place. Page 79. Page 79, item 4 with the compilation. Starts with page 79. Page 7. What had happened, just give few background. Some fraudulent order and the lease permission were created in the name of Waqf board as if granted by the board. Similar to this, that NA orders granted by the taluka officer. Wherein seals, stamps, and letterheads and everything has been manipulated. Similar to these allegations in the present case. Wherein one of the person, Mukesh Vanraj Jain, against whom the allegation was that he took the lease of the property on a fraudulent document. And just take my lords to the, it is the para 2. It is the case of the petitioner that an FIR is lodged by one Ajay Kumar so and so for the incident which is alleged to have occurred on 7. It is alleged that therein that the land bearing revenue so and so present serve number so and so, situated seam of village Jitali and serve number so and so, admitting so and so, situated the seam of village Jitali. It is alleged that said property belongs to old Masjid Jitali. It is alleged that Mr. Yusuf so and so registered the rent agreement in favor of Mukesh Vanraj Jain. It is alleged that video ordered it is again Gujarat State Waqf Board informed the Inspector General of Registration, Stamp and Registration Bhavan at Gandhinagar that no such permission letter was given permitting aforesaid premises for giving aforesaid permission on rent. It is also alleged that in outward register of Waqf Board, there is no mention of any such letter dated 20th of February 2016. Neither there is any application seeking permission for giving permission of the trust on rent. It is alleged that forged letter has been utilized as genuine one, and therefore the aforesaid complaint was lodged by the first informant, hence the present application. The arguments of the, in third para, arguments of the applicant has been recorded, and thereafter my submission has been recorded, and para 4 on, para 5 onwards. Similarly, I was also facing the, I was opposing the bail application, para 5. Few submissions which your lordship will find has an identical bearing. Strongly, am I with my lords? Para 5, strongly objecting the granting of anticipatory bail. Advocate Manisha, appearing for the first informant, submitted that the present petitioner is kingpin in main culprit. The present petitioner is a person at whose instance the forged order from the Waqf Board has been brought to the light, and upon which the lease of the property of the old masjid so and so has been executed for 29 years. The property of the old masjid trust worth crores of rupees has been leased to the present petitioner at meager price. He would further submit that in fact petitioner forged documents of Gujarat State Waqf Board dated 20th of February 2000 and used the same after many years, which prima facie indicates that the petitioner is the main kingpin in commission of the offence. He would further submit in fact of trustee masjid so and so were also misguided by the forged order which was issued in the name of the petitioner. As such, trustees of masjid have executed lease deed in favor of the petitioner. Forging a document in the name of petitioner itself indicates that the petitioner is the main person in grabbing the land of the Juni Masjid Jitali Trust. The petitioner has not only forged order of the Waqf Board but also used round C offenses made out against the accused. He would further submit that the local complaint was alleging that there are multiple transactions where the order of the Waqf Board are forged and pursuant to which either sale deed or Waqf property are executed or lease deed of the Waqf properties are executed. The similar kind of incident took place. Forged documents, orders were created by somebody, and the lease deed and sale deeds are executed, which came into light later on. And then the Lokayukt complained about this, and then the Inspector General of Registration inquired through the Waqf Board, and upon which Waqf Board confirmed that these orders are completely forged orders, based on which registered documents has been executed. Considering these submissions, the court has rejected the anticipatory bail application of that person. Now, the Honorable Court may have page 94. That person has approached the Honorable Apex Court. Apex Court considered his bail application mainly on two grounds. Page 94 order. Order. Yes, Lordship may just have FIR, same FIR. That the Honorable Court may consider page 91 in contradiction position of page 79. Page 79. The FIR number. So this is arising out of the CR number 111999061240016. Same CR number is in the first paragraph of the Honorable Apex Court has referred in third paragraph, and on page 79, the same CR number in first paragraph of Gujarat High Court judgment. Page 79 and 91 may kindly listen together so that FIR number would be. So this registered as CR number 111 identical of 9 January 2024. The offense is 465, 467, 468, 471, 120B, and 82 of the Registration Act. And the Apex Court has referred. Gujarat High Court judgment has referred these sections. Yeah. This is the recent order of 22nd of October 2023. May I read para 4 so that the substance on page 91, on page 90, paragraph 4. The prime, am I with me? Para 4 on page 90, 91. Yes, great. The primary allegation in the FIR is that the permission letter has been forged for grant of lease of worker property by the worker for a period of 29 years. It has also been alleged that the government permission which is required for grant of such lease which exceeds 3 years had not been obtained. Then the submissions are recorded of both the sides, and then the Honorable Court may consider para 7. Yeah, the conclusion arrived by the apex court. Considering the fact of joining investigation by the appellant as well as the fact that the allegations are required to be proved. I'm sorry. I read para 7. Yes, great. Considering the fact of joining investigation by the appellant as well as an interim order, the apex court has asked him to join the investigation. So did he join, and therefore the court observes, considering the fact of joining investigation by appellant as well as the fact that the alleged allegations are required to be proved mainly on the basis of documentary evidences. We are of the considered opinion that custodial interrogation of the appellant may not be necessary for completing the investigation. Here also, the IO's affidavit say the entire transaction is based on documentary evidences, and therefore the court has then granted it is directly in the event that the appellant being arrested, he shall be released on bail by the trial court on terms and conditions fixed by them. Needless to observe, the appellant shall not directly or indirectly making any inducement, threat, promise, resort any person acquainted with the facts of the case from disclosing such facts on any police officer to the court. We clarify the observation made in this order and grant of bail to the appellant in anticipation of arrest will not be treated as finding on the merits of the case. The appeal is accordingly. This is the recent order which the apex court has considered mainly on the ground that the allegations are based on documentary evidences. Almost identical fraudulent method. Therefore, I would request the Honorable Court that in this case also, the allegations are based on documentary evidences. And therefore, considering the fact that she is a lady, she has 60 years old, she is completely resident of Dahod itself, having roots in the society. If bail is not granted, she would suffer irreparable humiliation in the society. Therefore, the Honorable Court may kindly consider its bail application. Grateful, Great.
એને કરાવવા માટે તૈયાર હતી. કરીએ ને પ્રીમિયમ અલગ છે. આનામાં કલેક્ટર શ્રી જે હુકમ કરે આ શરત પર આધારે એમને આ હુકમ જેવો એ શરતનું પાલન નથી થયું, ખોટો હુકમ ઉભો કરાવવામાં આવે. એ હુકમ આધારે એમને સ્થળ પર આસપાસના મકાનો બની. એ જે વર્કશીટ છે એ તો ફરિયાદ સાથે તાલુકા કચેરી ત્યાંથી ફરિયાદ છે વર્કશીટ સાથે આવે છે. ફરિયાદ સાથે વર્કશીટ જે જાવક નંબરોનો એ યુઝ બતાવ્યો છે આ ઓર્ડર પર, એ જાવક નંબરો તો બીજા કોઈ કામ માટે વપરાય છે. એ સાહેબ ફરિયાદ સાથે અમારા પેપર્સ એમને નથી રજૂ કર્યું, અમારા પેપર્સ. ના ના છે, કારણ કે એમાં જે જાવક નંબર સર બતાવે એ જાવક આ જે હુકમો પર જે જાવક નંબર થી હુકમ છે એ જાવક નંબર કચેરી ખાતેથી તો અન્ય કોઈ કામ કરતે વપરાયેલા જાવક નંબર. આ એક જ વર્કશીટ નું એક કોમન આ છે. હા એ આમાં જ આવશે. આ વર્કશીટ જે રજૂ ના કોમન છે તેમાં આ વર્કશીટ જે રજૂ કરીએ એમાં આના પૂરતું જ છે બાકી હા એ જ હા એ જ આ છે વર્કશીટ કોમન છે બીજી વારાફરતી એક જ છે આખું પેપર આવતીકાલે છે મારી પરમ
ખાલી સર બે apprehension Malane has shown only two aspects. The investigation is going on. We are willing to cooperate whenever we are required. We are willing to cooperate. સબ જે પ્રીમિયમ નું વાત કરે છે કે પ્રીમિયમ ની ચોરી, we are willing to deposit by our own, not by the imposition of the courts. I have written in the bail application itself. That may be considered. Grateful, Manas. We are obliged for patient hearing. I am deeply obliged.
સેમ છે કોમન છે એ તો આખી સીટ જ છે આખી વર્કશીટ કોમન જ છે
We are great.
8784 નંબરની અપીલ છે કન્વિક્શન લે એમાં સમાધાન થઈ ગયું છે મેં આપ્યું છે બંને જણા આજે હાજર છે સિરિયલ નંબર 5 હા હા 138 બંને જણા આવી ગયા પરમિશન અરજી આપું ઓકે આપી દો આપી દો એ આપી દો એમને એડવોકેટ સાહેબ ફતેપુરા ગયેલા છે લાલપુર વાળા એ આવશે એટલે એમની સહી લઈ લઈશ આ બે જણની તો સહી લઈ લીધી છે એ વાત મારે થઈ ગઈ છે એમની સાથે હા હા બપોર પછી કહીશું મને 4-1 વાગે આવશે એટલે હું સહી કરી દઈશ એમ કહ્યું છે સાહેબ એક નંબર બે આરોપીઓ ના ના એને જાણે બે આરોપીઓ એક જોયા નતો અને બે માંથી એક એક્સપોર્ટિંગ થઈ ગયા હતા
એમાં 299 નો ઓર્ડર થયો.
હાજી હાજી
અરે આ એક જ બાજુ છે. કોરોના પછી એનો પત્તો જ નથી. ભોપાલ ગયો તો જીવે છે કે કેમ એ સવાલ નથી. એના ફાધરે ગુજરી ગયા, એની મધરે ગુજરી.
ગોસ્વામી
શોર્ટમાં લખવું હોય તો 61 છેલ્લા 4 આંકડા લઈ. સાહેબ એ જતો તો ને પાછળથી ટ્રક ખરી સાહેબ એને ટક્કર મારે. હા અને અમારા ક્લીનર જ ફરિયાદ આપી છે. મારા ક્લીનર જ ફરિયાદ આપી છે અને જે અરજદાર જે છે સાહેબ એ સામાવાળી જે ટ્રક હતા એમાં કંડક્ટર તરીકે હતા. હા અરજદાર સામાવાળા વાહનમાં ટ્રકમાં એટલે ક્લીનર હતા. ત્યાં સંપૂર્ણ જે અકસ્માત થયો છે સાહેબ એ સામાવાળા વાહન જે ટ્રક છે એની ડ્રાઈવરની બેદરકારીને લીધે થયો છે. આ કામે સાહેબ 30 થી ચાર્જશીટ બી રજૂ કર્યું છે જેસની વિરુદ્ધમાં. અરજદારને પૂછ્યું હતું સાહેબ ઉલટ તપાસમાં તો ટ્રકનો ડ્રાઈવર સ્થળ પરથી ભાગી ગયો હતો એટલે જણાવ્યું છે કે ડ્રાઈવર ત્યાંથી ભાગી ગયો હતો. કંડક્ટર જે બેઠો હતો ટ્રકની અંદર એને હું ક્રોસ મેલા હાલના અરજદાર સ્થળ પરથી ભાગી ગયો. નો ડાઉટ મુંડા સાહેબે ક્રોસ કરી એમાં એમને એવો પ્રયત્ન કર્યો છે કે અમારી બેદરકારી લીધે, પણ મેં જ્યારે એમને ક્રોસમાં પૂછ્યું કે અકસ્માત તમે નજરે જોયેલ નથી તેમને હા પાડી છે. હવે અમે બી સ્વાભાવિક રીતે સાહેબ કંડક્ટર હોય અને પાછળ હોય અને આખો અકસ્માત કઈ રીતે એક્ઝેક્ટ બન્યો એ ના ખ્યાલ હોય એટલે એમને બનાવ નજરે જોયેલો હોય અરજદારે એવું રેકોર્ડ પર આવે છે અને ફરિયાદ પરથી સ્પષ્ટ થાય છે કે અમારું વાહન આગળ હતું અને પાછળથી ટ્રકે ટક્કર મારેલી છે. એટલે અમારી સાહેબ કોઈ બેદરકારી નથી. એટલે સંપૂર્ણ 100% જવાબદારી છે ટ્રકની વીમા કંપની પર આવે છે. ચાર્જશીટ રજૂ કરી છે 8:45 થી ડિસેબિલિટીની પ્રોસેસ બી રજૂ કરી છે. હા ટ્રકના ડ્રાઈવર પર થયેલું છે. 11,550 ના બિલ છે એના સિવાય બીજું કઈ નથી. આવક અંગે કોઈ પુરાવો નથી રજૂ કર્યો અને અરજદારે સાહેબ કોઈ ઉંમર અંગે કોઈ પુરાવો નથી રજૂ કર્યો. 29ની ઉલટ તપાસમાં એવું જણાવે છે કે બનાવ જે એમનો જન્મ 1994માં થયેલો છે. નથી બધું મુખ્ય હોય તો જોઈ લો સાહેબ ફરી મારા નોલેજમાં નહીં હોય. એમને કીધું તું ખરું વિસલતાભાઈને રજૂ કરવા. થોડીક બેટર સાહેબ એક વાર સાહેબ મને થોડી અહીં મારા ખ્યાલથી બહુ ઝડપથી પતે આપું સાહેબ થોડીક અહીં આવી જાય સાહેબ તો એ સાહેબમાંથી એ સાહેબ નોટ ધીરે ધીરે આપજો સાહેબ પણ તમારો
પડી છે સાહેબ, એટલે ત્યાં બહુ જૂની પડી છે.
સાહેબ એક વસ્તુ બહુ નક્કી કે એક્સપર્ટ જે થઈ ગયા હોય ને સાહેબ એમનો ઓપરેશનનો હાથ જે પર્ટિક્યુલર ડોક્ટર દિવસમાં 10 કરતો હોય, પેલો મહિનામાં 5 કરતો હોય, 2 કરતો હોય તો એમાં બહુ ફરક પડે. અને આપણે એવું માનીએ કે સારા ડોક્ટર પાસે હંમેશા જવાનું સામાન્ય રીતે બધા પસંદ કરતા હોય. કિડની માટે સાહેબ બધા નથી નડિયાદ જતા સાહેબ, બીજે બધે છે પણ નડિયાદમાં વધારે પ્રિફર કરે. આપણી પાસે થોડીક મેટર આવે તો અમને બી થોડું સ્મૂથલી થોડું થઈ જાય, થોડી રાહત મળે ને આપ જલ્દી અમારી વાતને સબ સમજી શકો. બીજું કઈ નહીં. થોડીક 50-75 મેટર આવી જાય ને ભલે આપ પણ અમે સાહેબ સામેથી કોઓપરેટ કરીશું એમાં ચલાવવા માટે ને ખુલ્લા દિલથી કહી દીધું સાહેબ આમાં આવું જ કરવાનું છે, આપણે જે ઓર્ડર કરવો હોય. ઘણી વાર શું થાય કે સાહેબ અમારી વાતને કોઈ જલ્દી કદાચ ના સમજી શકે. ધારો કે કલાલભાઈ હોય ને અમે બે હોઈએ તો સાહેબ તમે હું અમને કહી દઈએ, હું ને LR પાઠક કહી દઈએ સાહેબ જજમેન્ટ જે આપવો આપજો, લાયબિલિટી 50 આની ગણવી હોય જે કરવી હોય સાહેબ અમને આટલું પૂરું કરીને આ ડિફેન્સ લાઈન પૂરી કરો. તમારે જે જવાબદારી કરવી હોય સાહેબ ફિક્સ કરજો. આટલું જ કહેવાનું હોય સાહેબ. અમુક તો અમારે સાહેબ કરવા ખાતર કરવું પડે. આપ બધું જાણો જ છો સાહેબ રેકર્ડ પર કે આવું આવ્યું. બીજું કઈ નહીં સાહેબ.
બ્રેક વકીલ એસએસ પરેખ ઘડી એન કપડે જોડા
પાડવાની અરજી અને સર તપાસ
લિસ્ટ પહેલું કર્યું
હા હા
કોણ છે?
સાહેબ આ લોકલ એ લોક અદાલત 14 હમણાં હું કરી હમણાંથી જીપીઆર આવે છે 5-10 મારું ને એક એમનું છે મારું એફડીઆર રિલીઝ નું છે લોક 20,000 ના રિલીઝ માટે એ તો તે વખત કંપનીએ કરતા આ રીતે આજે ઓર્ડર માટે જ હતું